Let me introduce you to Jude Okoro. Jude is not a legal scholar. He is not a multinational corporation with a basement full of lawyers. He is a craftsman, a small business owner in Lagos, Nigeria, who built a bespoke furniture manufacturing company from little more than raw passion, a workshop, and an almost obsessive attention to detail. His furniture wasn't just functional, it was art you could sit on. In early 2022, Jude received the kind of phone call every small business owner dreams about. Global Home Limited, an international retailer with showrooms across Europe and the Middle East, wanted to work with him. Not for a few tables or a custom chair. They wanted a long-term supply agreement for over $600,000 USD of premium, custom-made furniture. This was the moment Jude had been building toward for nearly a decade. But there was a catch. There is always a catch. The contract arrived as a 42-page document, drafted entirely by Global Home's legal team in London. It was dense, complex, and filled with language that felt deliberately distant. Jude read it 3 times. He understood maybe half of it. But he trusted the opportunity. He trusted his work. And like so many small business owners before him, he signed. Buried deep inside, not hidden exactly, but buried deep enough, was a clause that read, "The buyer may terminate this agreement at any time for any reason, and shall only be liable to pay for goods physically delivered and accepted. No compensation shall be payable for work in progress, materials purchased, or future loss of profit." At the time, it looked like a formality, a legal backstop, something that would never matter. 6 months later, it became everything. By mid-2022, Jude had done everything right. He had invested over $300,000 USD of his own money, plus money borrowed from family and a small business loan, into specialized hardwood, custom metal tooling, and production machinery adapted specifically for Global Home's designs. His workshop ran double shifts. He hired extra hands. He built prototypes, tested finishes, and created a streamlined manufacturing system that could deliver quality at scale. Then the email came. Due to a change in our global business strategy, Global Home Ltd. has decided to terminate the supply agreement, effective immediately. No warning, no negotiation, no apology. Under that buried clause, Global Home paid exactly $115,000 USD, only for the goods already delivered and accepted. Nothing for the work in progress. Nothing for the $300,000 in materials and tooling. Nothing for lost profit. Nothing for the months of sleepless nights. Jude sat in his half-empty workshop, surrounded by piles of custom-cut wood and half-finished furniture that now had no buyer. No one else could use them. Every piece was made to Global Home's exact specifications, their dimensions, their finishes, their brand identity. To any other retailer, these were expensive, useless oddities. His lawyer told him the truth. "We can try to fight, but the clause is clear. You signed it. And international arbitration favors freedom of contract." Jude decided to fight anyway. The legal argument, what Jude hoped would save him. Jude and his legal team didn't go in blind. They leaned on 3 of the most respected international legal frameworks in the world. 1. The United Nations Convention on Contracts for the International Sale of Goods, CISG. Over 90 countries have adopted the CISG. It is the global rulebook for cross-border commercial contracts. Article 7 of the CISG requires parties to act in good faith, honestly and fairly in their dealings. Jude argued that a clause allowing termination, at any time, for any reason, without compensation for work already performed, violated the very spirit of good faith. No reasonable business partner, he claimed, could invoke such a term without acting unfairly. 2. The Unidroit Principles of International Commercial Contracts. These principles are not a treaty, but they are widely used in international arbitration and dispute resolution. Article 3.2.7 of the Unidroit Principles addresses gross disparity, situations where one party has taken unfair advantage of the other, resulting in a contract that is unreasonably one-sided. Jude argued that a $300,000 loss versus a $115,000 payout with no compensation for materials or labor was exactly that, gross disparity. 3. WIPO copyright and design treaties through the World Intellectual Property, Organization's Hague System for the International Registration of Industrial Designs. Jude planned to argue that the designs and production methods he developed were his intellectual property. The furniture reflected Global Home's brand, but the process, the way it was made, was his. He hoped this would give him leverage. Maybe not to win the contract dispute, but to claim ownership over something valuable. The arbitration tribunal listened. They were not unsympathetic. In fact, one of the arbitrators described the outcome as commercially regrettable. But sympathy is not the same as justice under international law. The tribunal ruled against Jude on every point. Here is why. Freedom of contract is the bedrock of international commercial law. Two business entities, even if one is much larger than the other, are generally bound by what they sign. The CISG's good faith requirement is interpretive, not a standalone weapon. It can help a court understand a contract, but it cannot override a clear, bargained-for term. The Unidroit principles only allow a court to invalidate an unfair term if one party had significantly weaker bargaining power and no reasonable opportunity to understand or negotiate the contract. Jude had signed without independent legal advice. He had not asked for changes. He had not negotiated. The tribunal's words still echo. The terms may be harsh and commercially regrettable, but under international law, it is not our role to rewrite a deal freely entered into by two business entities. There was no appeal. International arbitration awards are final. Jude walked out with massive debts, a workshop full of useless inventory, and what looked like the end of everything he had built. Where law meets innovation. Most stories end here. The small business owner crushed by fine print. The cautionary tale. But Jude and his advisors did something most people would never think of. They stopped fighting against the law and started working with it. Not by changing the past, not by overturning the ruling, but by asking a different question entirely. What do we still own? Because here is the quiet truth that the tribunal's ruling did not take away. The contract was dead. The clause was enforceable. But property is not contract. And under global intellectual property law, Jude owned more than he realized. Step 1. Reframing ownership under global IP rules. The biggest practical problem was that all the unfinished furniture and custom materials were made exactly to Global Home's specifications. To anyone else they looked worthless, like a key that fits only one lock. But Jude's legal advisors introduced him to a distinction that changed everything. Under the WIPO Hague System for Industrial Designs, the law draws a clean line between decorative aesthetic features which can belong to a brand or buyer if contractually assigned, and functional structural features and production methods which belong to the maker unless expressly transferred. The finishes, the curves, the visible brand-aligned details, those were Global Homes in spirit, but the joinery techniques, the efficient assembly sequence, the material cutting algorithm that reduced waste by 40%, the custom jigs and tooling designs, those were Jude's. The contract had never mentioned them. Global Home had never asked for ownership of how the furniture was made, only the final appearance. Under international IP law, functional elements are protected separately from decorative ones, and those rights belonged entirely to Jude, regardless of the terminated contract. Step 2. Redefining the assets. Jude and his team formed a new company, Ingenium Design Solutions. Now came the creative and perfectly legal transformation, using the flexibility allowed under international commercial law, because no law forbids a creator from repurposing their own functional innovations. They did the following. 1. Redesigned all aesthetic features. They changed shapes, radii, surface finishes, color palettes, and visible detailing, just enough to create legally distinct new works. Under WIPO rules, these were original designs, free from any contractual claims. 2. Kept and protected the functional core. 2. Kept and protected the functional core. The efficient manufacturing processes, the tooling systems, the production workflow, everything that made the furniture high quality and cost-effective, remained their exclusive property under global IP rules. 3. Legally certified the new designs. Through the Hague system, they registered the redesigned product line as original industrial designs. No infringement. No transfer restrictions. clean title. Within weeks, what had been a pile of useless stock was transformed into a brand new premium product line called Legacy Bespoke. The same skilled hands, the same efficient systems, the same high-quality materials now reshaped into something that belonged entirely to Jude. Step 3. Turning conflict into partnership. Now came the boldest move, the one that required not just legal knowledge, but emotional discipline. Instead of suing again, instead of sending angry emails, instead of burning bridges on social media, Jude wrote one letter. Not a demand letter, not a legal threat, a proposal. Dear Global Home, you terminated our contract. Under international law, that was your right. I accept the tribunal's ruling. However, under the same international legal framework, specifically WIPO, intellectual property rules, we have legally repurposed all assets and functional designs into a new independent product range called Legacy Bespoke. These are not your designs, they are ours. No clause in our old contract prevents this. We are now launching globally, using the systems and craftsmanship we developed while working with you. We would welcome the chance to supply you again, not as a captive vendor under an unbalanced contract, but as a partner. This time under fair terms aligned with international best practice. No hidden termination clauses, no gross disparity. Just quality, consistency, and mutual respect. Global Home's legal team was stunned. Not because the letter was aggressive, but because it was unimpeachably lawful. They checked with their IP counsel. Jude was right. He owned the functional designs. He had clean title to the new product line. And he was offering them a way back to the table, not as a defeated supplier, but as an equal. They agreed. Not only did they avoid potential IP litigation, which they would likely have lost on the functional design question, but they saw the commercial sense in it. Legacy Bespoke was beautiful. The quality was undeniable. And Jude had proven something rare, resilience combined with legal intelligence. Global Home became one of Legacy Bespoke's first major international clients, under a new contract built on balanced terms, clear termination provisions, and shared risk. The outcome? A lost case that built a stronger business. Today, Ingenium Design Solutions, the parent company of Legacy Bespoke, is more profitable than Jude's original business ever was. He paid off his debts, expanded his workshop, and now sells to Global Home, the retailer that terminated his contract, plus 3 other international clients. He lost a legal argument. The termination clause stood. The tribunal's ruling was final. But he never lost the framework. Under WIPO treaties, decorative features can belong to a buyer, but functional elements, processes, tooling, manufacturing methods belong to the creator unless explicitly assigned in writing. Global Home's contract never assigned them. So Jude redesigned the aesthetics just enough to create a legally distinct new product line, while keeping his efficient production system intact. No loophole, no infringement, just creative, lawful restructuring. As Jude later said, I lost the case, but I never lost the law. I just learned to see it as a global framework to build with, not just to fight with. The innovation was collaborative. Jude brought the resilience and business instinct. His solicitors brought the legal architecture. That combination, creative thinking plus skilled legal execution, turned a lost case into a stronger business. A lost case is never the end. It is just the end of one strategy.